My journey into international law really began at the Summerhill Opportunity School, because I had gone from North Strathfield Public School in Sydney to Summerhill OC class, and there in 1948, which is 70 years ago, our teacher, Mr. Tennant, gave all of us a little document which was printed on airmail paper. Now, it's necessary to explain to people of the mobile telephone generation what airmail paper is or was. It was lightweight paper so that you could send several pages of a message internationally at the cost of ordinary paper, and that was extremely expensive in the days when that was how you communicated mostly internationally. The Universal Declaration of Human Rights had been prepared by a committee chaired by Eleanor Roosevelt, the widow of the late wartime President of the United States. Interestingly, it paralleled the history of the United States Constitution. It was expected that a Bill of Rights would be included in the Charter of the United Nations, but they ran out of time, just as they did in 1776, and therefore they committed this to a committee. Eleanor Roosevelt chaired it, and the head of the Secretariat was a very clever professor of law at McGill University in Canada, John Humphrey. Later, when I was appointed to be a member of the governing board of the International Commission of Jurists, I got to know John Humphrey. He was a commissioner from Canada, and he was a very interesting man, and it was wonderful to talk with him about the steps that were involved in drafting the Universal Declaration of Human Rights. All persons are born free and equal in dignity and rights. That's the word of the first article of the UDHR. And so in that sense, receiving it as a school child in Australia and getting to know the man who was the head of the Secretariat who drafted it for Eleanor Roosevelt, René Cassin and others, gave me a sense that I was there at the beginning of the journey of international human rights law. The Universal Declaration was adopted on the 10th of December 1948, and we will therefore later this year be having endless numbers of conferences talking about the UDHR, its impact, the way it gave rise to the great treaty system of the United Nations, which express in more detail and in binding terms the principles of universal human rights. Now, in 1958, 10 years later, I was aged 19 and I was attending the Sydney Law School. I'd come from up on the campus where we did our arts degree down to a very ramshackle building at the end of Phillip Street, and that is where I was taught international law by a very great and very influential professor, Professor Julius Stone. Julius was profoundly influential on many students whom he taught, less so on some, but many were influenced by his teaching, which was antithetical at the time to the received wisdom, which was that judges of appellate courts in deciding matters have what he called leeways for choice, and that in resolving ambiguities in a constitution, resolving ambiguities in a statute, resolving uncertainties or gaps in the common law, the whole system of the common law was one which adapted to its environment, and it adapted through the work of the judges, and particularly the judges in the highest courts. And that was quite different from what we were being told at the time by Sir Owen Dixon, that there was only one legal answer to one legal problem, and all you had to do was use the right techniques and it was objectively ascertainable. So Stone was a sort of semi-heretical teacher of a very important, but it seemed to me at the time, still does, a very honest appreciation of the leeways for choice which we have in our legal system. Subsequently, I used those leeways for choice in referring to international law, including the international law of human rights, and I'll come to that if we have time later on. In 1968, so we're talking now of 50 years in the past, I was a young legal practitioner. I was a member of the Law Institute, as it was then called, and I was beginning to plan my move to the bar, and that was early in my career, and there wasn't too much international law about the work that I was doing day by day. But by 1978, which is 40 years ago, I had become the chairman of the Australian Law Reform Commission, and in that commission we had been given a reference, the commission works on references, by the Fraser government on the protection of privacy. And at that time, the OECD in Paris, the Organisation for Economic Cooperation and Development, the successor to the Marshall Plan in the post-war world, had begun a project on the preparation of guidelines for the OECD on the protection of privacy. It had done so for a mixture of legal, economic and idealistic reasons. The issues of privacy were extremely important in Europe because of the then recent experience of the way, with ordinary old manila folders, terrible damage had been done, lives were lost because of access to personal records, personal information systems. And the OECD met for the first time in its expert group on this subject, and I was sent along because I was chairman of the Australian Law Reform Commission, which had received this reference to work on privacy. And because the Americans couldn't bear to have a European in charge of the project, because they feared that that would lead to a very heavy-handed data protection type approach, and because the Europeans couldn't bear the idea of having an American or a North American in the chair, I was elected to the chair, and thus began my career in international law. And I was a very good chairman. I still am a very good chairman. And instead of spending my teenage and post-teenage years going to dance parties and other such things, because of my sexuality, I spent it chairing SRC and other meetings. And I became really accomplished as a chair, and that gave me a great skill, and that led to other opportunities. The moral of the story is Australians can play an important part in international law, in the development of international law, but of course only if you get the chance. And you've got to seize the chance and try to get the opportunities, and when you get them, you've then got to use them to the hilt. the OECD guidelines were derived from work that had already been done in the Nordic Council. This is how things tend to happen in the international sphere. The Nordic Council had already begun to try to work out what the principles were for the protection of privacy and information systems because of the then very early international data systems, and it adopted a set of principles which it then sent to the Council of Europe, which is a body established in the late 1940s, 1950, and which developed two international conventions for the members of the Council of Europe. The object of the OECD committee was to draw on the principles which had been adopted by the Nordic Council and by the Council of Europe, but to put them in a context and in a format that would be acceptable in the intercontinental character of the OECD. The OECD is the rich countries club, and it included Western Europe, North America, Japan, Australia and New Zealand at that time. At that time it was only an organisation of 24 countries. It's expanded considerably more recently. The principles of the OECD were then adopted by the Council of the OECD, and those principles were then recommended to the member countries of the OECD, most of which then adopted the principles from the OECD for the purpose of expressing their own national laws on privacy protection. This was deemed relevant to the mandate of the OECD because the fear of the OECD was that if different countries had different rules on what you did to protect privacy and information systems, that would be a burden on the economies of the OECD countries trying to reconcile the different ways they approached it. And so that was the motivation for what was essentially a statistical and economic organisation getting into an area which was essentially a kind of human rights project. And so the OECD adopted the principles of the guidelines which I had a part in developing, and those principles were then recommended inter alia to Australia. And when the Fraser government did not implement those principles, it depended on the change to the Hawke government, which in one of its first acts adopted the OECD principles as a schedule to the Australian Privacy Act. Now that taught me that an international organisation where it is useful, where it is economically advantageous, can formulate principles which can then be borrowed and used to mutual advantage by countries in that organisation. And I was very impressed with the OECD. It meets on time, unlike a lot of UN meetings. It is efficient. It had a brilliant secretariat, and it worked very hard, and we got the job done very quickly. So that was my first real engagement with international law, and because I did it very well, if I say so, modesty will get you nowhere in this world, so you've got to be, I'm being truthful to you, I was a very good chairman, and that then started to get around. And so I began to get requests from all and sundry to get involved in international activities. We've got to get that Australian with the fruity voice to come, because he's very, very good in extracting consensus from the participants. And so we don't have time this morning to go through all my glorious activities over the last 40 years, but I'll just mention a few. For UNESCO, I had the pleasure of chairing an expert group on who are a people for the people's right to self-determination. You know that the two international covenants, the common first article of the two refers to the people's right to self-determination, which is itself something that was derived from the 14 points of President Woodrow Wilson in 1917, 1918, so that's a century ago. This is how these things happen in international law, and the principle of the right of self-determination of peoples immediately raised the question, who are a people in international law for the purpose of that principle? And so a committee of experts was formed. I was the chair of the committee. Judge Keba Mbaye, a judge of the International Court of Justice from Senegal, very, very clever man, subsequently vice president of the International Court of Justice, was a member, and the committee drew on work that had been done by Professor James Crawford, now a judge of the International Court of Justice, in defining who are a people. And we said a people are a group. It has to be a large group because it's for the purpose of international law. They have to have institutions that allow them to express their wishes as a people, and they have to desire to be seen in international law as a people. These criteria were adopted by UNESCO, and they are probably the best description of what is a people for international law. And the issue that is raised by the common first article is relevant to our own Aboriginal people. Our own Aboriginal people in Australia are people for the purposes of the common first article of the two international covenants who enjoy a right to self-determination. A right to self-determination doesn't necessarily get fulfilled by separation and by expression in different nations. It can be expressed within the one nation, but the issue of who are a people for this common first principle was a not unimportant question for us in Australia. The other work that I did within UNESCO was on bioethics, and I chaired the committee of UNESCO which drafted the Universal Declaration on Bioethics and Human Rights, but we don't have time for that. I was also asked by the World Health Organization to become a member of the original Global Commission on AIDS. Global Commission on AIDS developed the principles of WHO on how the world would respond to the AIDS epidemic. That was a dreadful time when AIDS came along. There were no therapies that were of much use. The only therapies that were ultimately found in those early days were old cancer drugs, which had been developed, were not much good for cancer, but some of them, such as AZT, was found to have some value in dealing with HIV. And the work of the Global Commission on AIDS of the World Health Organization was extremely influential, including in Australia, in advocating a paradoxical approach to the epidemic. That is to say that instead of stepping up the punitive approach or locking people up, the best way in the predicament of the early days of the epidemic was to reach out to the groups that were most affected, who included men who had sex with men, sex workers, drug users and others, in order to get into their brains the fact that there was a very serious virus about and that they had to protect themselves from body fluids and that the best way to do that was by winning their confidence and reaching out with messages to them, because we didn't have a pill that we could give them to combat the spread of HIV. And later in that decade, I was appointed to my first task under the then Human Rights Commission of the United Nations as Special Representative of Secretary General Boutros Boutros-Ghali for human rights in Cambodia. That task was what was called a special procedure of the United Nations, and involved reaching out to human rights groups in Cambodia and trying to assist Cambodia to build a human rights respecting society and constitution. Unfortunately, emails received as recently as yesterday indicate that things are a bit grim in Cambodia at the moment, but the United Nations has an office there. The United Nations office has continued to try to put pressure on the government of Cambodia to respect the human rights of the people of that country. Now, in the decade after I was appointed to the High Court, because of the separation of powers doctrine and the fact that the international affairs is the responsibility of the executive government of the Commonwealth, I had to back out of my international activities, and basically, although I remained involved with the International Commission of Jurists, I did not take part in UN activities at that time. But that gave me the opportunity to reflect on what I'd learned in my UN activities for my work as a judge. Those questions were raised in a number of cases in the High Court of Australia during my service in that court. And they in turn arose out of my instruction from Julia Stone. Some writers have said if you want to understand the Mason High Court, you have to understand that the Mason High Court included 5 justices who had been taught by Julia Stone. They accepted the realist jurisprudence that judges, that you're not on automatic pilot. It is just not possible to say there's only one solution, and that being candid about the matters that have influenced your decisions is a judicial duty. Exactly 30 years ago, when I was still on the Court of Appeal of New South Wales as President, I went to a conference in Bangalore in India. That was a conference that drew together a number of judges from Commonwealth countries. It was chaired by Justice P.M. Bhagwati, who had until then recently been the Chief Justice of India, a very influential judge in India. And the only non-Commonwealth judge who was present was a young female judge from the DC Circuit Court of Appeals in the United States by name Ruth Bader Ginsburg. So Ruth Ginsburg and I were there. We were the only judges who were not from final courts, and she was soon to be translated to the Supreme Court of the United States, where she still is at 80, still sitting in the Supreme Court of the United States and showing no inclination to retire. You know, if I had had the opportunity I can understand that point of view. But anyway, she came, and that really taught a stone-like principle. Where there is an ambiguity, the judge should reach out to the developments that are happening in international law, mostly in international public law, but also in international private law, to fill the gap, resolve the ambiguity, and that was what I started to do in the Court of Appeal in New South Wales. generally with the support of my colleagues, because it was a useful way of resolving problems that we had before us. And lo and behold, in 1992, before I was appointed to the High Court of Australia in 1996, the High Court, in the case of Mabo against Queensland number 2, decided to disturb 150 years of land law and to substitute the principle that the Aboriginal people were entitled to recognition of their land rights. And where did they get the authority to take that very big step? It was a big step. I remember reading about it when I was President of the Court of Appeals, thinking, wow, that's a big step for the court to take. Well, they applied the Bangalore principles. There is a passage in the reasons of Justice Brennan in 175 Commonwealth of Law Reports 1 at 42, it's written on my mind, which says that where an issue is before a court of the common law, where there is no constitutional or statutory impediment, and where the court is looking to the principles of the common law, the court can look to international human rights law, as in the International Covenant on Civil and Political Rights, because it is inevitable that those principles will come to influence the development of the common law. It's a very important passage, and it's essentially, though it didn't expressly mention the Bangalore principles, it was doing what I was doing in the Court of Appeal then in terms of cases which were coming before me. Now, that decision was, I thought, the opening up of new opportunities in the law, which were essentially opportunities that responded to the contextual element of the world in which our laws now operate. I mean, whether we like it or not, the law of Australia now operates in a context of an international community. And the international community is increasingly active in the development of law. It's increasingly doing so in matters of trade because the new technology has developed the opportunities and necessities of trade. But it's also doing so in the public law area and in the field of human rights. These are not just motherhood statements, these are principles of international law, and many countries, most countries, and especially countries like Australia, have signed on to the principles of international human rights law, and therefore, it seemed to me, the context of the international law in which our constitution now sits influences the content of our legal system at home. If you take, for example, the word jury in section 80 of the Australian Constitution, you remember that is the section that says for an indictable federal offence it shall be tried by jury. Now what does jury mean? Back in 1901, a jury, and for very long after, a jury meant 12 men, M-E-N. Moreover, it meant 12 men of property. They were the local ratepayers. That was what jury meant to the founders. And if we were purist in a originalist interpretation of our Constitution, we would simply look up a dictionary of 1901. This is what Justice Scalia said he did in the United States. You would just look up 1901 dictionary and say, well, a jury means 12 men, but we don't do that. We look at our Constitution in the context of our society of today and of international law and of the international law against all forms of discrimination against women. And in that way, the international law comes to influence how we see the word in today's context. There are many, many illustrations in the Constitution of the Commonwealth, and those illustrations, I think, bear out that it is inevitable that a contextual interpretation will be adopted in constitutional reasoning. And so that is what I endeavoured to do in the High Court. There was a case of Al-Kateb against Godwin, very famous case. Every law student knows Al-Kateb because Al-Kateb raised the question of whether in 2004, when Al-Kateb was decided, we should interpret the Australian Constitution in the context of the central principles of international human rights law, that you can't lock people up indefinitely and that they have to be subject to restrictions on the duration of their incarceration. But in Al-Kateb, the theory of the Commonwealth was Mr. Al-Kateb, who couldn't be returned to Palestine because Israel wouldn't allow him to pass through Palestine, and couldn't be returned to any other Arab country because they wouldn't take him, just had to stay in detention, immigration detention in Australia forever. Justice McHugh asks in his reasons, what is the problem with detain? It means detain forever if necessary. That's Al-Kateb and Godwin. In that case, three justices, Chief Justice Gleeson, Justice Gummow and I, didn't agree with that. Chief Justice Gleeson and Justice Gummow reached their view by a process of interpretation. I agreed with them, but I said there was a more important constitutional context that was in play. So these are the ways in which I think international law is coming and is bound to come. There will be die-in-the-ditch resistance to this by some people, but if you think about the realities of the world in which our legal system operates, it seems to me to be inevitable. Now, one thing Professor Stone taught us, apart from jurisprudence and the leeways for choice, was international law. And 1958, when I was at the Sydney, 68, when I was at the Sydney 58, when I was at the Sydney Law School, was only less than a decade after the Korean War. Little did I imagine that years later I would be dealing with the aftermath of the Korean War, because in 2013 I was appointed by the Human Rights Council to chair a commission of inquiry on North Korea. We don't have time to go into the details of this, but a very good book has just been published, written by our own Michael Pembroke. This is Justice Pembroke of the Supreme Court of New South Wales. And this is a book on the Korean War, and it's subtitled Where the American Century Began. And it's a very useful book because it demonstrates that part of the problem of dealing with North Korea is that they were subjected to carpet bombing the length of the peninsula, and virtually everybody in North Korea lost family in the Korean War. And the strategy of intense carpet bombing had been copied from what was done in Dresden at the end of the Second World War, and it left behind in North Korea a community which is very anti-American and very fearful of the United States of America. And Justice Pembroke's book is a very good explanation of the issue. But this doesn't excuse North Korea for its abuses of human rights, and the report which my committee and I produced had to deal with that issue. In the end, the Human Rights Council strongly supported the report we produced. That was endorsed by the General Assembly, and then a little provision of the Charter of the United Nations was found, which had been copied from the Covenant of the League of Nations. And that provision applied an exception to the operation of the veto. You possibly know this, you probably don't, but there normally the P5, the permanent 5 members of the Security Council, have a veto, and if they don't concur, it doesn't get passed by the Security Council. There was a similar provision in the League of Nations, but they had made an exception in the case of procedural resolutions, where it was enough that you had a 2/3 majority of the League. Similarly, in the Covenant, I think it's Article 48, says that procedural matters should be decided by a 2/3 vote. The explanation for that at the time was that the ambassador for Italy might be held up the Brenner Pass and unable to get to Geneva for the vote in the League of Nations, and we shouldn't hold up procedural matters by issues of that kind. Italy was then a great power, it was a P5 equivalent, and that is what is provided for in the Charter of the United Nations. So the work of the committee was a response of the international community to the challenges of human rights, and it was a faithful fulfillment of the principles that Eleanor Roosevelt and John Humphrey and the other members who prepared the Universal Declaration intended should be done. I want, in concluding these remarks, only to now mention 2 other little stories. One of them relates to the way in which, even in private legal problems, the developing law, international law, can sometimes influence the activities of lawyers in practical cases. At the moment, I am chairing an international commercial arbitration which involves billions of dollars, and an issue arose in a matter relating to the building of a dam. And ultimately, on that particular matter, the parties reached agreement between themselves for the settlement of the matter. But the question became, does that settlement involve any environmental issues upon which it shouldn't only be the parties who are heard, but also others who might be affected by the environmental outfall of what was done? In the end, the matter was sufficiently satisfactory to the arbitral tribunal, and it didn't hold up the settlement. But it is an illustration that even when you're involved in an international commercial arbitration, nowadays, and I would think increasingly in the future, the development of international principles to respond to climate change and to the environmental protection generally are going to influence what is done by private practitioners at work. The final story relates to a book which you must all read. This book is by Philippe Sands, Professor Philip Sands. He is a French UK citizen, and it's called East-West Street. Professor Sands will be coming to Australia next week, And in fact, he is giving a talk and participating in a concert at the Sydney Recital Hall on the 17th of February. And the book is a book of his life and the life of his family. His family came from a town in what is now in Ukraine, but which was in Poland, called Lemberg. That was the name of the town when it was part of the Austro-Hungarian Empire, Lemberg. It was the third biggest city of the Austro-Hungarian Empire. It subsequently was renamed Lvov, and subsequently, when it changed hands once again, renamed Lviv. It is at the moment called Lviv. And the story is not only about the loss of most of the family of Professor Philippe Sans, but also about East-West Street. It was originally called Lemberger Straße, but in Lvov times it became known as East-West Street, and it was the street in which at one end lived the Lauterpachts, and at the other end lived the Limkoffs. These were two Jewish families, and the two of them produced two extremely important international lawyers. The Lauterpachts produced Hirsch Lauterpacht, later to become a professor of international law at Cambridge University, and subsequently elected to the International Court of Justice as Sir Hirsch Lauterpacht. And the other, Raphael Lemkov, became the exponent of the international crime of genocide. And the story of the book, because it has an intellectual content as well as a historical content against the background of which world history was played out, is that these two boys from Lemberg, Lviv, had different theories about international responsibility for serious crimes. And these were the differences that Hirsch Lauterpacht believed that in every case you had to have an individual intent, and therefore that it was a matter of individual crimes only, whereas Lemberg believed you could have crimes done against a whole people, as he asserted had been done against the Jewish people and the Gypsy people and other people in the Second World War. At the Nuremberg trial, the view of Lauterpacht prevailed, but in 1948, 3 years later, the view of Lemkov prevailed because the Genocide Convention was adopted. And little did I think that my work on North Korea would involve the resolution of this issue, because in the submissions that we received in the inquiry into North Korea, it was submitted that the government of North Korea was responsible for genocide against people, a group of the population who were dying or being killed, or starving to death in famine, and that was a form of genocide. And in popular parlance, it might be so. But the problem is that when you actually look at the Genocide Convention, it says that genocide is an act of state of a nation against a population or part of a population on the basis of their race, ethnicity, nationality, or religion, and doesn't mention politics, which was the issue in North Korea. So even in that case, there was a question which gives me a special interest in this book by Professor Sans, and which will be expounded in the Sydney Festival in 2 weeks' time. So if you haven't got the book, you should buy the book. And it's a very interesting illustration of how international law is developing. It is not just all motherhood principles. It has detail, it has content. In the end, in North Korea, we held that genocide had not been established, because in the case of North Korea, the killing of a large part of the population was on the basis of their political opinion or inferred political opinion against the regime. It wasn't on the basis of race, ethnicity, nationality, or religion. And so these are issues of lively importance in the international sphere. So that's basically all I came to tell you today, and the moral of the story is you've got to try to do what you can to get involved with international law, because it is a coming wave. And even if you're not involved, as a practitioner, you've got to be alert to the developments that are happening, because they will be increasingly relevant to the resolution of legal questions in Australia. So we'll have a big round of applause, and then we'll have some Q&A. Are there any questions? Short questions and short answers.
We should discuss international humanitarian law alongside human rights law.
Absolutely. And in fact, in the case of North Korea, we said that it was important that in the sanctions which were being applied against North Korea, those sanctions should respect international humanitarian law and should not impose inconsistent burdens on the ordinary citizens of North Korea, because they're not responsible for the cruel actions of their government. So definitely, obviously, yes. At the moment, the sanctions of the Security Council, which have been increasing and which can only be adopted, because that's not a procedural matter, that's a substantive matter, can only be adopted by the unanimity of the P5, do have some exceptions. But when I was in the Security Council last December, the Secretary General's representative said that if any country felt that the principles of the humanitarian law were not being applied, considered that was a matter that could be put up to the Sanctions Committee in the Security Council, and exceptions could be crafted that ensured there would be exclusions from the sanctions. Any other questions?
Behind you.
Yep. Thank you, Judge.
Not a judge anymore.
You're a judge emeritus, aren't you?
No,
not even
in
a judge
Australia,
emeritus.
the people give you the title, and the people take it back.
Unlike the US, where you are
Well,
forever.
in the US, if you're a street cleaner, any kind of title you get forever.
Precisely. No, my question was about Myanmar and about international pragmatism versus humanitarian law. That the value of investment in Burma by major corporations around the world, is that going to override the genocide that's happening against the Muslim people that are being kicked out?
Yes, I've generally kept out of Burma, Myanmar, because of the fact that I've got enough on my hands with North Korea, and North Korea's enough controversy. There are issues in Burma of the clash between the Buddhist and the Islamic population, the clash between people who have come in from Bangladesh and the mass of the population, the much greater birth rate amongst the Rohingya than there is amongst the Burmese, and that is the perspective which the Burmese have of the issue and of their right to self-determination over issues concerning them. But that right to self-determination doesn't extend to genocidal and crimes against humanity, which do appear on what one reads to be happening. There is always a clash between pragmatism and principle. Look at North Korea. I mean, it took a long time for the countries of the Security Council, and especially Russia and the Russian Federation and China, to get alongside Western countries and support sanctions. But they are now doing so because I think everybody is deeply concerned, not just about the human rights situation in North Korea, but also about the proliferation of nuclear weapons. Because if it isn't dealt with in the case of North Korea, the real question then is what is going to happen in the next case, where another country, small in number but ingenious in scientific developments, develops a nuclear weapon that puts the rest of the world in risk. I think it's disappointing that the Australian government has decided to have nothing to do with the ban treaty. You know that a treaty was tabled in the General Assembly last July, the 7th of July, which was designed to respond to the International Court of Justice call in its advisory opinion on nuclear weapons, that we've got to start reducing the stockpiles of nuclear weapons. I mean, if you just pause for a moment and think rationally, is it not at least possible that there is going to be some accident or some mistake, or somebody will have a feeling of rage and something terrible and devastating will happen? And therefore, as a species, unless we address this issue through international law, and it can only really be dealt with in an international way, we have a major problem for the long-term survival of the human species and other animal, other life. The body ICANN, which won the Nobel Prize for Peace, was actually established in Melbourne. It started in Melbourne, and they won the Nobel Prize for Peace, and they have been a major force for the ban treaty. And when people say, oh, well, the Americans are never going to give up their 27,000 nuclear weapons, they say, well, we've got to start. We've got to do something. And until the Permanent Five do something, then nothing much is going to be done by other countries like North Korea. So somehow we have to address this issue. And that's why international law is so important and has to be invoked. And I hope that the Australian government, like the New Zealand government, under the former regime, will become involved in these issues. This is really urgent and important.
Should we just have one?
Any other questions? Yes.
In 10 years' time or so, what international disputes do you think we'll still be discussing?
What?
International disputes, regions are still in conflict. What do you think we'll still be discussing? North Korea, Ukraine, Russia, these aren't new disputes, as those books both discuss. So what do you envision in 10 years we'll still be discussing in a room full like this?
Well, we were a body set up by the Human Rights Council of the United Nations. Therefore, we could not say that a member country of the United Nations, namely the Democratic People's Republic of Korea, should be wound up, and there should be something put in its place which was democratic and complying with the United Nations. We had to accept DPRK, and we had to say, but if you join the United Nations, which you don't have to do, if you join it, you have to conform to the Charter, you have to cooperate with its instrumentalities like the Commission of Inquiry, and you have to conform to the universal principles of human rights, which they don't do. So I think it's uncertain how this is going to play out, but one thing I would caution against is the feeling that everything has suddenly evaporated, North Korea is being sweet. We had that in our inquiry. When the Commission of Inquiry was getting very strong traction
and very strong support in the Human Rights Council and in the General Assembly, North Korea turned on a charm offensive because they didn't want to have the report tabled in the Security Council. So they were saying, oh, well, we will allow the Special Rapporteur on Disabilities to come. And maybe we'll have discussions about inviting the High Commissioner for Human Rights to visit North Korea for the first time. And all sorts of charm offensive things were done. This is how North Korea operates. So I wouldn't be thinking that North Korea has changed its spots, unfortunately, and that it's all going to be different during and after the Winter Olympic Games. I think this is just part of the strategy that North Korea adopts. Therefore, vigilance and insistence, especially where there are probable crimes against humanity happening, is an obligation of the international